You got a criminal record, and you think your immigration dreams just died in a courtroom. But hold on, because the story is way more complicated than that. Moral turpitude sounds like something out of an old-timey western, like a villain twirling a mustache, but it just means a crime involving dishonesty, fraud, or intent to really hurt someone. Not every crime counts as a CIMT, and that surprises almost everybody. A parking ticket will not end your green card dreams, but something like theft, fraud, or assault with intent absolutely raises red flags. Here is the plot twist nobody tells you. The government does not look at what actually happened. They look at the legal definition of the crime itself. This is called the categorical approach, and it means two people who did wildly different things can get totally different immigration outcomes based on how their state wrote the law. So you might be thinking, okay, I messed up years ago, am I doomed forever? Not necessarily, because there are actual legal doors you can walk through, and this is where an immigration lawyer becomes less like a helper and more like a locksmith. One option is called a waiver, specifically under a section immigration nerds call 212H. Think of it as asking the government for a permission slip that says, yes, this person messed up, but they deserve a shot anyway. To get that waiver, you usually have to show something dramatic, like extreme hardship to a spouse, parent, or child who is a citizen or lawful resident. Extreme does not mean mild inconvenience. It means real suffering, like losing medical care, financial ruin, or family separation that would seriously damage their life. There is also something called the petty offense exception, which sounds like a superhero side character but is actually a lifesaver for some people. If the max possible sentence was 1 year or less, and you were not sentenced to more than 6 months, you might dodge the CIMT label completely. Timing matters too, because there is a rule about crimes committed within 5 years of getting admitted to the United States. Commit one CIMT within that window, and the punishment can be way harsher than if it happened later. Here is where people panic and make it worse. They try to explain everything themselves to an officer like they are auditioning for a legal drama. Please do not do this, because immigration law is not a vibe check. It is a maze of statutes, and one wrong sentence can trigger permanent consequences. A lot of folks assume a pardon fixes everything like a magic eraser. Sometimes it helps, especially a full and unconditional pardon from a governor or president, but it does not automatically erase immigration consequences the way people hope. Expungements are another huge myth, because in criminal court it might look gone, but immigration law often still sees the original conviction like a ghost that refuses to leave the house. This is why so many people get blindsided years later during a green card interview or citizenship application. Preparation is basically your superpower here, gathering court documents, sentencing records, and police reports before you even talk to an attorney. Judges and officers love organized humans, the same way teachers love a kid who actually did the reading. Rational thinking beats panic every single time in these cases, because emotional decisions lead to rushed filings and missed deadlines. Slow down, get documentation, and treat this like assembling a puzzle instead of running from a fire. The honest truth is that CIMT cases are unpredictable. Some people get relief easily, and others fight for years, and there is no shortcut that fits everyone. If you want real guidance instead of internet guesswork, do you want to learn more about how we can help? Check out our links in the description.